Hi, welcome back to the CX Update. I'm your host, Dennis Wakabayashi, and today we're going to be talking about the recent hot water that Apple and Spotify are in when it comes to AI. Earlier this month, Universal Music Group began sending takedown requests to popular platforms like Apple and Spotify. They requested that the services block music scraping robots that fill AI libraries with existing content. This is, of course, how people use AI to conjure those newest bangers from the libraries of existing artists. And to be fair, it's kind of scary how easy it is to use these tools to compose a song with lyrics like Jay-Z, vocals similar to Justin Bieber, and in the style of Elton John. And in some cases, these new songs are covers of existing songs, which is probably what tipped off UMG to the copyright issues in the first place. And for those just catching up, the music industry is just the latest industry to start trying to cancel bots. Last year, we saw Microsoft's GitHub sued for copyright infringement when he used public code to train the Copilot AI. Then there was a slew of class action lawsuits against DeviantArt, Stability AI, and Midjourney, all who developed first-generation AI visual studios using the Stable Diffusion platform. And you may remember from one of our previous discussions that we saw AI-generated artwork had trouble removing watermarks from places like Getty, which probably gave them more than enough reason to sue Stability AI for scraping their libraries. Anyway, these legal battles are just first of many, but they will set the stage for every content creator, digital library, and customer experience in the future. It's truly a battle over the rights of human artists and the freedom for robot creations. And I think it's telling that amidst the current backdrop of lawsuits, companies like OpenAI, the creator of ChatGPT, are already preparing for lawsuits by beefing up their internal legal teams and retaining outside lawyers. So there's that. But I think the real question is, what are we supposed to do as customer experience professionals? And to answer that question, I've invited Wendy Schechter to talk to us today. Wendy is a partner at S-Squared Advertising Law and foremost expert in the field of advertising and marketing law. Thanks for being here, Wendy. Can you help us understand how AI and copyright law work?
Copyright law protects original works of authorship that are fixed in tangible form, and that includes musical compositions and sound recordings. So AI-generated music presents some really unique legal challenges, particularly regarding copyright. Probably the most pressing issue is the fact that AI generators ingest huge quantities of existing copyrighted music, which is how it learns how to then generate AI created music. And the question there is the AI's use of the existing copyrighted music copyright infringement? We don't have a real answer to that yet. There is a court case that is pending that has to do with visual images and its use in AI, but whatever that ruling is will impact AI music as well.
How can streaming platforms and music labels work together to protect both artists and consumers?
This reminds me of the very early days of music streaming. And now, like then, the music labels and the streaming platforms are going to have to work together to find ways to balance the interests of both the creator as well as the customer who wants to be able to listen to AI-generated music. So that might mean that streaming services are going to have to figure out ways with the music labels to detect and block AI music that is infringing. And I think a really important part of this is going to be transparency, because the customer should be able to know what the music they're listening to is. Is it AI generated or is it not? And that will give the customer much better listening experience.
What advice do you have for agency executives who are looking at AI technology to enhance brand customer experiences?
They need to tread lightly as they enter into this new arena. And I would advise they work very closely with their legal counsel when they're assessing AI-related risk, particularly in the area of copyright. And they also have to be careful that they're not over-promising their clients anything as well, nor are they potentially infringing on their agency client agreements, because often those agreements require that the agencies give all the copyright in the materials they're creating to their client. And it is still an open question whether AI materials can be protected by copyright.
Thanks for sharing, Wendy. We appreciate you taking the time to help us learn about the future of copyright law.
My pleasure. Thank you so much for having me.
So where does that leave us today? It's pretty clear that AI is better at recreating content than most humans. And the fact is, these tools will only get better and better, and establishing new legal norms will take years. Meanwhile, the challenge for all of us will be finding the balance between embracing innovative technology and protecting the rights of those who create the content we love. On that note, that wraps up today's update. And before we go, I'd like to thank today's sponsor, ApptEdge. ApptEdge is a new leading AI company transforming the customer service industry with their GPT answer engine. Their answer engine replaces legacy customer care solutions with an entirely new approach to satisfying customers. If you'd like to learn more about ApptEdge, I'll leave a link to them in the description below. If you'd also like to connect with Wendy, I'll do the same for her. Thank you again for being here. I'm Dennis Wakabayashi, and I'll see you at the next update.